Right, I think we'll make a start. We've got lots of you in already. So welcome to our webinar today. It's the third in a series of 4 on various insolvency issues. And of course, today we're dealing with dissolution and restoration. Thank you for joining us. I hope you find it useful and informative. A few housekeeping points, if I may, to start. Your microphones are automatically muted, so you don't need to do that. Your videos are automatically turned off. If you've turned it on, please turn it off. And we're going to record the webinar, and the recording and the slides for all of the talks in this series are going to be uploaded to our website. Now, we're unlikely to have time to take any questions during the webinar, but if you've got any pressing general queries on the topics we're covering today, do feel free to ask them. You can ask them in the chat section on Zoom, or you can email them to webinars@landmarkchambers.co.uk. And what we'll do is try to compile answers to some of them, and we'll send those answers out in due course. We're not going to deal with them today. We'll be about half an hour, give or take. And if you lose us at any point, if your connection gets dropped or whatever, you can just rejoin us by clicking the link that you clicked on to get here today already. Okay. I'm joined this afternoon, I'm very pleased to say, by Evie Barden, who has recently joined us from elsewhere. The great thing about doing this talk with Evie is that, as I understand it, she's planning on writing a book all about restoration, so she's a real expert on the topic. And we're going to take you on a whistle-stop tour of some of the key issues arising in a property context when a company is dissolved. So what happens to the property that belongs to it, the real property? What happens to options, things like break notices, and how do you restore the company where necessary, and more besides. So we'll start with an introduction, and then we'll touch on some of the more knotty issues that can arise. So what do we mean by dissolution? Well, it's where a company is struck off the register at Companies House. Why will it happen? Well, lots of possible reasons. The purpose of the company may have reached its natural end, so we might be dealing with a single purpose vehicle, a development company, for example. The company might have failed to file statutory returns, and that can lead to automatic strike-off. Or perhaps the company has simply failed and the directors have brought matters to an end. It matters not. But you now find yourself wishing to take action with respect to the property that the company owned prior to dissolution. What do? Well, the starting point is to appreciate that the company has ceased to exist. So unless you take steps to restore it to the register, you will not be able to serve notices on the company, nor will you be able to bring any proceedings against it. It's ceased to be, it's no more, it's bereft of life, and it rests in peace. It is an ex-company, but unlike the parrot, it can be brought back to life. That brings us on to, of course, the Bona Vacantia division of the Government Legal Department. And the starting point is that all property, cash, and other assets will automatically pass to the Crown. That's section 1012 of the Companies Act 2006. And where we're referring to sections in an act in this talk, we are talking about the Companies Act 2006 all the way through. The property that will automatically pass includes leasehold property, but it won't include property that's held on trust for someone else. Now, for ease, we are referring to the Crown. In fact, it will either pass to the Crown or the Duchy of Lancaster or to the Duke of Cornwall, and that will depend on where the company's registered office is and where the property is located. So we're just going to, for ease, refer to the Crown, but bear in mind that the GLD department will only deal with property vested in the Crown. You will need to go via the solicitors for the Duchy of Lancaster or the Duke of Cornwall to make progress with property that falls within their remit. I think that's Farrer & Co. are the standing solicitors. Now, the Crown has 3 years from the date where it becomes aware that property is vested in it to serve a notice of disclaimer. So given it's an automatic vesting, the Crown has the right, particularly used where it's onerous property, such as a short lease, to disclaim that property. And if the Crown wishes to give notice of disclaimer, the disclaimer will take effect 14 days later. Now that gives time for a party that's been notified, such as an underlessee or a mortgagee, to apply for a vesting order. You have that short window. Now, if the property is disclaimed, the position is as if the property in question never vested. So we turn to section 1015, and that provides that the Crown's disclaimer will operate so as to terminate, as from the date of the disclaimer, the rights, interests and liabilities of the company in or in respect to the property disclaimed. So, for example, if it's a leasehold interest, the lease comes to an end as between the landlord and the tenant. Subsection 2 goes on to say it does not, except so far as is necessary for the purpose of releasing the company from any liability, affect the rights or liabilities of any other person. Who might that other person be? Well, it might be a tripartite lease, it might be that there's a charge holder or a subtenant. So far as possible, the disclaimer will not affect their rights. Now, it's a pretty complex subject beyond the scope of today's talk, but you need to be aware of the point. And the starting point is to look at a case called Hindcastle and Barbara Attenborough Associates. It's a 1997, appeals case is 70. Those of you who attended the last talk, so number 2 in the series, may have heard Nick Grant touch on this subject in the context of disclaimer by liquidators under section 1784 of the Insolvency Act, which is a near identical provision. So that's the effect of disclaimer. Now, bear in mind the Crown has 3 years from the date it becomes aware of the property having vested in it. Bear in mind that in most instances where a company has valuable assets, these are going to be dealt with in the liquidation prior to dissolution. So it's usually where something's gone wrong, often, you know, a failure to file an annual return, something like that, that the need to deal with a vested asset arises. And because the Crown is often unaware that property has vested in it, the 3-year period often doesn't start to run until some time after strike-off, potentially many years. Now, the Crown cannot disclaim property if it takes possession or if it expressly waives the right to do so. And it's for that reason, amongst many others, that you will struggle to get the BVD department to do, well, pretty much anything with respect to the property. I've seen many a client try in vain to get the Crown to pay rent and service charges. It's just not going to happen. For the same reason, the Crown will almost never register property in its name. The land registry records will continue to show the former company as the registered proprietor. And so, of course, by section 58 of the Land Registration Act 2002, the former company remains the admittedly non-existent entity liable to pay the rents. Now, if you want a bit more information, I've included the link at the bottom of this slide, a pretty useful starting point when you're looking to deal with an asset that might have passed to the Crown as Bona Vacantia. It's useful principally as it gives you a very clear steer as to what their likely approach is going to be if you write to them and ask them to do something. They cover many a common situation. Now, whether or not their approach is always correct is a different matter, but you'll have a good clue as to what their response is going to be if you work your way through this paper. And then there are links from this paper to specific guidance on dealing with a wide range of situations. So there's specific papers dealing with land, commercial leases, and also freehold reversions. There's a specific provision for freehold reversions because of the impact on enfranchisement. Now, a few key points to take from those, but as I say, do follow the link. If an asset has value, the Crown will only sell at full value. Now, of course, you can debate what full value is, and the Crown will probably want you to pay for it to investigate what the full value is. But it's a matter of negotiation. Nonetheless, you're unlikely to pick up a bargain. The Crown is not going to insure the property. It's not going to pay any liabilities. It won't sell if it's not cost effective to do so. They won't give any form of title guarantee if they sell, and they also won't help resolve any problems if there's no benefit to the Crown to do so. The Treasury solicitors will, in most instances, not get involved if you ask them to do something. If the land in issue is a freehold reversion to residential property, they will usually only sell the reversion to the lessees or an RMC, something similar to that. They're not going to sell it to an investor. and they will never sell for less than £1,000 plus their costs. That's a figure that goes for all property, in fact. So if the lessees are not interested in the freehold reversion, they will usually disclaim. And of course, they're not going to provide any services to lessees. If you ask them to disclaim a commercial lease, they usually will, and they'll usually do so promptly, and they will never assign them. This is all essentially about trying to avoid liability to the Crown. Other instances where they will usually disclaim include land used in common, so roadways, verges, amenity land, anything that's dangerous or onerous, and land subject to multiple charges or competing claims. They just won't get involved in those competing claims. So for all those reasons, you'll often find that the Bona Vacantia process isn't terribly helpful to your situation, but nonetheless, that's where the land immediately goes. So that, of course, takes us on to restoration. Now, the starting point, of course, it's the responsibility of directors and shareholders to deal with the property and the assets of the company before it's dissolved. So Bona Vacantia should be avoided by ensuring that assets and property are transferred or dealt with before the company is dissolved. If you're a former member, shareholder, or liquidator of a company and you want to get an asset back from the Crown, possibly one that you should have dealt with previously, you're going to need to restore the company, or you're going to need to buy that asset from BVD for open market value. Equally, if you're a third party to the company, so you might have a superior or derivative interest and you want to take steps in respect of an asset, or you want to sue the company and rely on its undisposed of assets for recovery, or then you're going to need to bring it back to life as well. Now, if the court orders restoration, the company comes back to life. So the Bona Vacantia no longer exists, the asset belongs to the company again. However, if whilst the company was dissolved, the Crown has disposed of the asset, then of course the asset doesn't come back and belong to the company again. However, the Crown will pay whatever consideration they received from the sale, less their costs, over to the company. And that's sections 103.2 and 103.4. Who can make an application? That's section 1029, subsection 2. Amongst others, a former director, any person having an interest in land in which the company had a superior or derivative interest, any person having an interest in land or other property that was subject to rights vested in the company or that was benefited by obligations owed by the company, and any person with a potential legal claim against the company. So a reasonably wide range of potential applicants. When can the court restore the company? Well, that's section 103.1.1. You can see it on the slide there. So the court can restore the company to the register if the company was struck off by the registrar by the powers to strike off defunct companies, and the company was at the time striking off, carrying on business or an operation. If the company was struck off voluntarily and any of the requirements in sections 1004 to 9 were not complied with, or in any other case, if the court considers it just to do so. Potentially a reasonably wide range. And then, of course, the restoration will take effect only on the court's order being delivered to the registrar of companies, section 103.1.2, and that timing is important. Now, the effect of the order, as I say, is that the company is deemed to have continued in existence as if it had never been dissolved or struck off. That was section 103.2, subsection 1. But at the time when the court makes its order, the court can also give directions as seem just for placing the company and all other persons in the same position or as near as may be as if the company had not been dissolved or struck off the register. That's section 103.2.3, and that's an important power, and one that really you need to give some thought to in terms of what further directions will be needed upon the restoration. So Evie, how long after the company's been struck off can we make an application to restore?
Well, you've got lots of time. You've got at any time if you're bringing an application for the purposes of bringing a claim for damages for personal injury. But for most of us, that's not really going to be relevant. So in any other case, it's 6 years from the date the company was dissolved. unless you've applied for an administrative restoration and that's been refused, in which case you get an extra 28 days, but your admin application has to have been within the first 6 years after the date of dissolution also.
And what's a limitation direction? When am I going to seek one of those?
Well, as you said earlier, the court can make any directions as seen just for putting the company or any other person in the position that they would have been in had the company not been dissolved. So that includes making an order that the time while the company was dissolved doesn't count for the purposes of limitation. But that is notoriously hard to get, and you've got a sort of two-stage process. So the first hurdle you've got to overcome is you've got to show it was probable that proceedings would have actually been issued if the company hadn't been struck off. So there's got to be some causal link between the lack of issuing and the fact that the company was struck off. Is the dissolution really the reason why the proceedings weren't started? And if you get over that first hurdle, the court still has to consider whether it's just to make the direction. And it's probably not going to think that if the company was deliberately dissolved, because why should the company get another bite at the cherry to the prejudice of people who would have the benefit otherwise of the limitation defence? That brings me on to discussing the effect of section 1032, which is sometimes called the as you were provision. As you said earlier, Simon, this puts parties in the position that they would have been in had the company not been dissolved. So it's a deeming provision. The company is deemed to have continued in existence as if it had not been struck off or dissolved. And it sounds pretty simple in some ways. For example, property revests even if it's been disclaimed, but it can operate in quite complicated ways. And as you said earlier, Simon, it's pretty obvious then a non-existent company can't, for example, commence or continue proceedings or serve notices, for example, to exercise an option. In any event, who's going to do that on their behalf? Who's going to have authority? Especially in the situation where a company was dissolved following liquidation, because as soon as the company goes into liquidation, the directors don't have authority to do anything on behalf of the company, and the liquidator will have been released from office before the dissolution occurs. So it's something to be aware of if you're acting on behalf of a company and you're signing a statement of truth in proceedings. If the company is actually dissolved, there might be the risk of a breach of a warranty of authority claim against you for signing that statement of truth. What then happens if someone does try to do something like issue a claim or serve a notice? Are those acts given the kiss of life because of section 1032? And there's a case called Jodrell and Peaktone in which a claim was brought against a dissolved company. And once the company was restored, it applied to have that claim struck off. The Court of Appeal said when the claim was issued, the proceedings were a nullity, but the effect of section 1032 is to validate all acts done in the name of or on behalf of the company while it's dissolved. So that seems like a complete answer, but one does need to be a bit careful about Jodrell and Peaktone. If nothing else, because it has been criticised, its thinking has been criticised by Lord Justice Lewison in a more recent Court of Appeal case called Davey and Pickering. And I'm going to take you through another case in a moment, which shows that the deeming provision doesn't make every act valid and doesn't unwind all acts in the period while the company was dissolved. The reason that section 1032 is particularly important is that things do happen while companies are dissolved. People do issue claims or serve notices against or on behalf of dissolved companies. And it's also important for risk assessing your options when something is time sensitive. For example, where a notice has to be served by a specific date, and that specific date is while the company is dissolved. As you said earlier, Simon, about the process to restore, you can do it by admin restoration, or more commonly by application to the court. And those applications are to Central London. And as we all know, Central London isn't the quickest at getting things listed. Restoration applications automatically actually come back with a 3-month return date. And the reason for that is because you won't get the company restored without the consent of the Treasury solicitor. And that can take a little bit of time to obtain. So it's actually quite hard if you need to get the company restored urgently to do something. The quickest I think I've seen it done was 9 days from issue of the claim, and we were hounding the Treasury solicitor and the court to get the claim listed. So what about contracts where there's an option to terminate on dissolution? I think your starting point at the moment should be the case of Bridge House Bradford No. 2 and BAE Systems, which was heard by the High Court last year. And in that case, what happened was that BAE and BB2 had entered into an agreement where BAE would procure the sale of 2 properties by one of its subsidiaries to BB2. Before the date for the sale to occur came about, BB2 was dissolved, and BAE gave notice to terminate the agreement because that dissolution amounted to an event of default. The company was restored very shortly afterwards, about a month and a half later, and it then went about challenging the validity of the termination by an arbitration clause in the agreement. The arbitrator said the notice of termination validly terminated the contract, and it wasn't undone because of the restoration. And on appeal to the High Court, the court said that decision was right. But it had a little bit of trouble because of Jodrell and some earlier cases. The difficulty seems to me that the court obviously wanted to hold the parties to the specific agreement that they'd made, and not allow BB2 to get out of the bargain that it had entered into. So the basis for the court's decision was to carve out what it called direct and, by contrast, indirect or secondary consequences of dissolution. The judge said that if the termination of a contract does not flow or be automatically a consequence of the dissolution, then the deeming provision in section 1032 will not undo the termination. So in this case, the other party had decided to exercise its right to terminate because of dissolution and had taken the necessary steps to bring about the termination. As a result, the deeming provision didn't catch the act. I have to confess, I find that formulation quite hard, and it's difficult to see where you'll draw the line and how that doesn't muddy the waters from what Jodrell says. But as I say, the third bullet point on this slide, an example given in the BB2 case, which is pretty helpful for property litigators, is the comparison between forfeiture of a lease, which occurs automatically because of the dissolution of a company, which wouldn't be unwound, versus forfeiture for non-payment of rent, which would be unwound because non-payment of the rent, it said, is a direct consequence of the company not existing. It can't pay because it literally isn't around to do so. So it's not a choice. So how might that impact break notices or any options to terminate? Well, generally speaking, you might have an option that's exercisable on or after a specified date on compliance with any conditions in a lease. And unless the lease is terminated for another reason, or there's been a disclaimer, it continues. So it seems to me, if you're the non-dissolved company, go ahead and exercise your option if you want. And it's likely that even if the company is restored, the as you were provision means the exercise of the option is valid. Who you might serve your notice on is going to be a bit more of a difficult question. If you have to give notice under the terms of the lease to a lessor or lessee as a question of principle, because the property is vested in the Crown. It seems that to me it ought to be the Crown, unless your lease specifies a specific way of serving or there's some sort of deeming provision. But I flag it because Bridge House, I think, muddies the position. The notice to terminate in that case was sent to the company, and there's no reference to there being any sort of deeming provision in the contract, in the judgment. So why wasn't the notice ineffective for that very reason? The point wasn't taken, but I'd be aware of it. What about the converse situation where you were the tenant and you had an option to renew, exercisable within specified time limits, but you're dissolved while that time limit comes about? I think you possibly lost your right to exercise the option unless you get a direction akin to a limitation direction, and that's going to be fraught with the difficulties that we discussed earlier. You could take a punt and just serve the notice, but that's obviously risky with regard to authority. Arguably, however, the notice is going to be infused with life once the company is restored. The only other way I can think of around this might be possibly to get a receiver appointed to exercise that right, but this is a pretty novel idea, and query who the receiver is actually acting on behalf of. It's going to depend on the wording of the option, but if the person with the right to exercise it is the person with the proprietary interest at the time, that's the Crown, and the Crown is not going to be very happy if you get a receiver appointed to exercise a right over property it owns. And the other thing is going to be, how do you comply with any conditions, e.g. payment of rent? As Simon said earlier, the Crown's not going to perform any covenants, so that's going to be another difficulty for you, unless that's going to be part of your the direction that you ask the court to make on restoration of the company. What about urgent relief? What about the situation you might find yourself in where, for example, the company has a valuable claim, but if no proprietary or freezing injunction is made imminently, it will be pointless to restore the company because the only asset will be dissipated? Or what about if something urgently needs to be done on property? A wall might be collapsing on neighbouring premises where the neighbour is dissolved. You could get a damages claim you could bring a damages claim once the company is restored. But what do you do in the interim if the wall collapses without something being done urgently? You might be asking, why have I got a picture of some nails on this slide? And it's not just because we're in week 10 of lockdown and everybody needs their hair and nails done by now. The actual reason is that there was a decision last year called Re-Yuzu Hair and Beauty Limited, which is a pretty helpful one and one worth being aware of. It suggests that a director or a shareholder can get a freezing injunction, and I would think by the same token a proprietary injunction if it's made as an adjunct to an application to restore a company. It's not entirely clear to me what the power to make the freezing order was in Re-Yuzu. So at the first hearing of it, Mrs. Justice Falk made it on the company's application, which is obviously wrong. And then at the return date, Mr. Justice Zaccaroli considered it in some detail and made it by analogy with where a petitioning creditor can get a freezing order against a third-party debtor, being someone that the company has a claim against. And that power is effectively, I think, a derivative action, but I'm not really sure how that works if the company doesn't exist. So I think you could try this if you're acting for the company, but you do have to be aware of that potential issue of principle, and the fact that in Re-Yuzu, the application was unopposed. And it also looks to me like it was really a broadly merits-based decision, because the prospective defendant was the accountant who had allegedly defrauded the company and had been the cause of the company's dissolution. So then what about my second hypothetical situation, where something's occurring on the dissolved company's old property and you want to get an injunction? Well, you're going to have difficulty doing that against the Crown, because Section 21(1)(a) of the Crown Proceedings Act 1947 says no injunctions can be granted against the Crown. It allows you to go and get an interim declaration if you want, but I'm not really sure how that's going to help you. You could ask the Crown to disclaim, but if it's freehold property, it escheats, so it's a case of to me to you, and you'll know further on. Perhaps your best solution here really is self-help. Go and prop up the wall or enter onto the land and remedy any disrepair. We're always quite wary of that solution as property litigators, I think, but it might be your best bet, because really the only other thing I can think of is my novel receivers point that I raised earlier, which you'd be looking to get under Section 37 of the Senior Courts Act. It's a pretty wide power. The court can make an appointment where it's just and convenient to do so, and it might be quite attracted to it here because there might be a risk to life or injury, and there's no prohibition under the Crown Proceedings Act to a receiver being appointed. But as I said earlier, you're going to find the Crown probably doesn't really like this idea at all, so not an easy way through. I think that's probably all we have time for today. So thank you everybody for joining me and Simon on this brief tour of the law of dissolution and restoration. As Simon said earlier, if you have any questions that you didn't manage to ask during the course of the webinar via the chat function, please do email webinars@landmarkchambers.co.uk. We will be collating those and any questions asked throughout the course of the webinar, and we'll try to put a paper together answering those questions. Thank you very much again, and have a good day.